Good afternoon, everybody. So far, we've looked at the basics of civil rights, the legacy of racism, and finally, the last video that we ultimately looked at was voting rights. What I hope you've been able to see is the profound influence that the African American civil rights movement had on later movements. And we're about to look at those later movements and how they affected a variety of different social groups. The key thing is that these groups were certainly involved well before the modern African American civil rights movement in the 1950s and 60s, but it was the mass movements and the mass mobilization of them and their lobbying of Congress that served as a template and a model for a number of civil rights leaders. Now, where I want to start off in the discussion is looking at the map of the United States. And this map was taken about 2 years ago. So it's changed even since then. What I want you to notice about it is that many states have already become what are called majority states. In other words, whites are not the majority in many of the states we see throughout this area here. And obviously, that trend is continuing across time, which is why, as we explore the civil rights of these other groups, it's extremely important to look at how these growing minorities are being impacted by these. Whether or not we're looking at Latinos and Asian Americans, which are the two largest growing minority groups right now, or whether or not we're looking at other groups, such as African American minorities here that are continuing to come in larger and larger numbers as well. So let's go ahead and start with looking at Native Americans who weren't immigrants at all. They were here well before we were. What I find especially disturbing here with each of these statistics, and you can see this for yourselves pretty plainly, is that whether or not you're looking at unemployment rates, college graduation rates, high school graduation rates, income levels, indoor plumbing, each of these in every single standard are lower for Native Americans than they are for white Americans. And what I find so striking about that is that if we're going to look at equal protection under the law, given the incredible oppression that Native Americans have faced in the past, we have to ask ourselves the question, okay? Are Native Americans still facing much of the same discrimination and the oppression that they have faced from our country in the past? And that I'll leave that question to you. But clearly, Native Americans are taking matters into their own hands with setting up casinos and the like. But are the state governments doing what they can to protect those rights for Native Americans? Is the federal government doing that? I'll let you think about that. Latinos began growing in their own activism as well. And I want you to catch the date for this specific case. This is Hernandez v. Texas. And this is the same year as the Brown v. Board of Education ruling. And what I want you to see about this is that the Warren Court, it was led by Earl Warren, made a pretty stark decision at this time. And what they're ultimately saying is that equal protection under the 14th Amendment, okay, is ultimately applicable to all non-Caucasian races. And that granted them the ability to become jury members. And I know most of you guys are like, God, who wants to be a jury member? But you got to remember, if it's only white people sitting on the jury, and you are a Latino that's suspected of murder, and all you see are white faces, is that a concern to you? Part of the goal in having diverse jury pools is that we don't run into those sorts of situations. So this is a pretty big deal as far as this specific case is concerned. Now, Latinos also pushed forward in the case Plyler v. Doe. In this specific case, a county within the state of Texas was denying illegal immigrants a public education, arguing that, look, the states are providing the funding for this public education, and these illegal immigrants are not paying taxes. Therefore, they don't have a right to this public education. The court disagreed in this specific case, and what they ultimately determined was that the 14th Amendment does not distinguish between them, and they're ultimately relying on that Hernandez v. Texas case as well to help make that decision. In other words, anyone within the United States has a right to a free public education. So this case, largely, guys, when I've had my students looking at a variety of different education cases in the past, this is the one that they hold above all others, which I think is pretty interesting on that front. And I imagine why is that there are a number of students that come from immigrant backgrounds. So this really hits close to home for a number of them there. The next group that I want to look at that's been impacted by a lot of this are Asian Americans. And you often hear the term model minority for Asian Americans. And you hear statements made about their aptitude in various academics. There are a number of Asian American civil rights leaders, though, that argue that that whole statement of model minority is a myth, and that it does more to hurt Asian Americans and their chances at attending top universities within the country quite a bit. Moreover, I think it might be important to distinguish between different Asian American groups. I mean, is it fair to treat a Chinese student the same as a Hmong student? A Hmong student the same as you would a Pakistani student? Asians, by the way, guys, are 2 billion people on this earth and more. That's China and India alone. So it's such a huge part of our world population that we want to be careful before we make those kinds of generalizations, not just on a personal level, but hopefully on a grander level at the state and federal level also. How have Asian Americans been impacted by our country's decisions in the past? Well, hopefully last year you took a look at Japanese internment. And in that, you found that Japanese citizens were deemed a threat by our nation, and therefore the Supreme Court justified its actions in Korematsu versus US in detaining those individuals. Now, what's been found since that time is that the security threats that they posed was information given to them by the Pentagon. Since that time, research has determined that much of that was based on a lie. And in the last few years, the court has apologized for making that decision, but the determination that groups can be interned based upon national security threats has yet to be squashed by the courts. So it's possible we make a return to that question of interning different minority groups based upon wartime concerns. Which, and we talked some on this in earlier videos, connects to Muslim Americans. We looked at the last video, one of the earlier videos that was made about the right to a speedy public trial impacting Muslim Americans, and they're absolutely being impacted by that. We can see actions right after 9/11, the anti-Muslim crimes spiking significantly, with Trump's talks of travel bans against Muslim groups and countries with predominantly Muslim populations being impacted by that as well. It's important to ask ourselves how Muslims are being impacted by those kinds of actions today. There isn't as much talk of travel bans. The federal courts have put some limits on that, and the Trump administration has had to qualify some of those terms, but has it been enough? Now, women, obviously, are half the population. You can't even accurately call them a minority, which is why I think it's important that when I started to refer to this as how a variety of social groups have been impacted by the African American civil rights movement. Now, the 19th Amendment was established in 1919. Immediately after that, Alice Paul and the National Women's Party put forward a huge effort towards passing the Equal Rights Amendment. That effort lasted for several decades. And 1970s is when it really started to take hold. But up to now, they did not meet the requirement of the number of states to ratify the Equal Rights Amendment. There's been talk of bringing it back, but as of now, the statute of limitations has ultimately made the ERA dead on arrival, which means that you would kind of need an ERA 2.0 in order to bring it back. But it is worth noting the gains that women have made. You can see the labor force, women have made tremendous gains in the workforce since the 1950s up to 2017. Women are also the larger population on college campuses. Those are things that absolutely should be recognized. Okay, these are some important gains that women have made. However, you still hear much talk about a gender pay gap and a variety of different areas of where that's charged. You'll hear determinations of 77 cents, 82 cents. There is debate about whether or not that's a fair charge, that some of those occupations require different skill sets or they require a variety of different aspects. It's up to you to determine whether or not you think that there's legitimacy or merit to that, but there are charges that women are not being treated equal before the law as far as employment is concerned, and that's worth noting. It's also worth noting that women are nowhere near 50% representation within the House or the Senate. But some would charge that, look, a representative represents the whole nation. It doesn't matter whether or not they're a woman or Chinese or African American. And that's a fair argument, but we'll see whether or not you agree with it. Women have been making huge gains in universities as well, but it's worth noting that a lot of these campuses aren't exactly creating the same equal protection. Remember, it's equal protection under the law. And if you're having large numbers of sexual harassment or sexual assault, this is not providing that for women. And this leads us to our discussion on Title IX. Title IX, you can see, is part of a larger act of Congress, so it's a statute. But what this reads as is no person in the United States shall on the basis of sex be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal assistance. What's important to note about that is a lot of people assume that Title IX only has to do with like equal funding for sports programs, making sure that if you have a baseball program, the softball program receives the same funding, receives the same resources there. But it goes a lot further than that, and I hope you can see that in the flyer here. And I'm hoping that these kinds of flyers and this kind of awareness allows college campuses to provide those protections for women. But if women aren't getting the same protections, you can imagine that the LGBTQ community is receiving even less. And that still remains the case. You can see this headline here from a year ago, how the Trump administration's transgender troop ban is affecting one military family. The House is responding to that, and you ultimately see that here. But these are challenges in part because, again, gender is not protected at the constitutional level yet. And whether or not that gender is woman, male, or part of the LGBTQ community is a bit of an issue there. And perhaps that requires additional statutory or constitutional action. And when I say those words, guys, I'm just talking about, like, is a new constitutional amendment still required, like an equal rights amendment? Should that equal rights amendment include verbiage for the LGBTQ community or not? That's up to you to decide. There are some potential challenges that are creating the largest challenges for the LGBTQ community, and that is the area of the claims of free exercise of different religions. In other words, I don't believe if I am a state official, I might argue that I believe that it is a sin to grant the same family rights and the same business rights to the gay community than I do other people. And the reason for that is that it's against the Bible. Now, whether or not you agree or disagree, this is happening in a variety of different states there. And you can see that on some of the map here, some of the states in terms of the actions that they're. This has also led a number of states to ultimately create laws that are stopping transgender bathrooms. You've heard some case maybe about setting up neutral bathrooms, not the male symbol or the female symbol, but just unisex, or simply having special bathrooms for transgender individuals. Some of these states are taking measures to ultimately stop that. So you can see that this has posed some real challenge for the community there. However, this particular case was a huge step forward. Many of you already know that gays can get married, but it's important to note what case granted them that ability. And it is Obergefell versus Hodges. Now, guys, it's worth noting that literally a decade before this, the court was still ruling on whether or not states had the authority to prohibit gay sex. So to go in less than 2 decades in allowing full marriage rights is a pretty big deal. And the grounds on which they do that, okay, is stated pretty clearly here by Kennedy. But Roberts poses an interesting question, okay, and that he's arguing that this is a choice, or this is a matter that should have been left up to the states. If you'll recall, it is the states that make these determinations about marriage laws, not the federal government. So again, he's charging, much like the court charged in the Brown versus Board of Education case, that the court was legislating from the bench again, that this was an act of judicial activism. But as of now, it is the law of the land. Where gay rights go from this point remains to be seen. Thanks for the time, guys, and Have a good day.